Good morning. Today I am going to discuss with you two interesting stories. Number one, Annie Gurema Kaur was student of BA Honors Economics, underwent a course with Delhi University of Delhi. Initially, she was successful, but in her Indian economy too, she was not satisfied with the marks. Therefore, she opted for revaluation of the mark. That was considered, and therefore, her entire marks, after adding the revaluation mark, she stood first in the BA economics. Therefore, she applied for medal, which was prescribed for the highest scorer of in economics faculty. But that was denied by the university. Therefore, she, being a Kaur means Punjabi, Singh, Sardar, Sikh community. The initial name of all women in Sikh community will be the same of the male name. But finally, when the Kaur denotes that she will be woman. She may be woman, she is woman. That is their customs. Here, AAR 2022 note on case, NOC, Delhi 597. AAR 2022 NOC 597 Delhi. Annie Gurmeher Kaur versus University of Delhi held that it is clear error on the part of examiner in evaluating her performance. Therefore, the result of it will not be taken into consideration for our and price is arbitrary. Respondent directed to award and prices jointly to petitioner and the candidate who was earlier declared proper. So this was the judgment. So she fought well. So this judgment may answer your clients if any is being affected in a similar nature or other circumstances which may be similar to the present circumstances. I hope you understand. AAR 2022 NOC 597 Delhi and AAR online 2022 Delhi 844. Why am I also adding? Because note on cases will have only ratio. If you want a full judgment, then you have to go to AAR online 2022 Delhi 844. Name of the petitioner Annie Gurmeher Kaur versus University of Delhi. Then you can download the entire judgment. I hope you understand. Another interesting case, a fantastic case wherein the Article 226 was aptly and invoked for relief of sons and daughters. This story is very interesting. You see, Madhumita Das seems to be very rich and powerful. She was having a lot of jewelry in SBI, Nagarlingam, Kisan Patra, National Savings Certificates, multi-number of national savings, bank balances, post office saving account, fixed deposit, recurring deposit, bank locker, and other fixed and returning deposit. Apart from that, she was having huge land at Calcutta and also land at Jalpaipuri. They approached the sons and daughter, left out sons and daughter, approached the High Court of Guwahati, stating that the mother became unconscious and at the coma stage. Therefore, when the maintainability was raised about appointing guardian for the mother, whether this writ petition is within the ambit of maintainability or not. Therefore, the AR 2022 Guwahati 120 Ayan Kumar Das versus Union of India passed a judgment, doctrine judgment, referring so many judgments, Supreme Court judgments. Particularly, they have discussed about the act which deals with the appointment of guardians. Guardians and Wards Act 1980, Mental Health Act 1987, the persons with disabilities, equal opportunities, Protection of Rights and Full Participation Act 1995, repealed, the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation and Multiple Disabilities Act 1999, then Rights of Persons with Disabilities Act 2016. This is substituted the repealed Act of 1995, the Mental Health Care Act. These acts were discussed. Finally, they say they distinguished what is vegetation stage and coma stage, and held that this clear case that she is in coma stage. Very pathetic seems to be some of the portion of the brains were removed and subsequently reattached. What not this old lady was suffered. The judgment was delivered on 6/4/2022. The hue and cry of the mother and petitioner was that they are not in a better position to spend more money for our mother, though heavy money is there with banks and other authorities. Finally, they have passed an order stating that petitioner was appointed as guardian of his mother in excess of writ jurisdiction. So this is most important. For appointment of guardianship, writ jurisdiction was invoked. It's a very fantastic, what we say, somewhat new turn of exercising writ jurisdiction. I understand the judgment. You can follow it. AR 2022 Guwahati 120 Ayan Kumar Das versus Union of India. AR 2022 Guwahati 120 Ayan Kumar Das and another Union of India the others. So this is the effort of an advocate who was successful, and the court was also inclined to exercise the plenary power for the rescue of the needy people. I hope you understand this judgment. Very doctrinal. If you really want to understand what all are the problems faced by her, so many things. If I read brain death, they are discussed about brain death, what is difference between coma and vegetative state, and finally they have held that this lady was in stage of coma. Why this? They say what is difference between vegetative stage and coma? The patient who is in coma can hear, can understand the surroundings, but vegetative stage is totally different. That's what I understand. You go through the entirety of judgment, and then you can also have little bit knowledge about the so much of incidents being happened at so many places, wherein sudden pathetic adversity strikes, despite the fact that the victim was having huge money in his account, huge estate also. So far, only they want the bank should be allowed to operate the account by sons and father, is subject to some other conditions. That's what I say. I want to say that the Indian Succession Act, Administration of Estate, will, appointment of guardian, all this should be regularized by a new act. Because the old act, letter of administration, appointment, grant of probate, is very old. I don't think the conditions, the bond executed by the High Court are being followed, whether the High Court is having time to do that, whether these procedures of present procedures is apt, and there was no access to commit fraud, get unfair degree, or possibility of abuse of process of court. Let us hope for this Indian Succession Act revisiting. Just like yesterday, Amit Shah told that the CRPC, IPC, and the Indian Evidence Act is going to be revisited and consolidated to the present circumstances because of the social engineering process of change in the society. Best wishes.